Hello, everyone. Welcome to Candid Conversations with LegalPay. This is an education initiative by LegalPay where we invite industry experts, the leaders of their domain, and decode the sweat, blood, and success behind their promising combination and perseverance across decades. I am Kashish Grover, Chief Investment Officer at LegalPay. Currently, we host a majority of this seminar in educational context, and today we have a very, very special guest with us, Mr. Hiroo Advani, who needs no introduction and is very prominent, specifically in the world of arbitrations. He's the founder and chairman at Advani Law and president of Indian Arbitration Forum, has been on the panel of varied arbitrations against different domains and rules, including Singapore International Arbitration Center, Kuala Lumpur Region Center of Arbitration, London Court of International Arbitration. Recognized as one of the leading dispute resolution lawyers by Legal 500 India and an A-list lawyer by the Indian Business Law Journal, Mr. Advani has been known to have won a large number of multi-billion-dollar awards in international and domestic arbitrations. Thank you so much, Mr. Advani, for taking out time speaking with all our viewers today.
Thank you for that very kind introduction. And let me just say a very few brief words first, how I started my practice and in which direction it has flown. And then I'll leave you to ask me any further questions.
Absolutely.
I started the practice as a counsel in the Bombay High Court, as it was then known as. My father was an eminent senior counsel. I was practicing in his chambers for a few years. Till one day I came across some interesting American gentlemen who were in the oil and gas business and who had some problems. And I found that the clauses did have a dispute clause. So I started arbitration, and for all the wrong reasons, it paid 10 times more than anything that I could earn as a counsel. So I quickly switched. And then I did a further switch when they told me that we're very large companies and our rules are we cannot engage individual lawyers. So I started my law firm Advani and Co., which included me and one peon. So that I was then officially, they could engage me for their more prominent and large matters to do arbitrations, and then slowly added on to that. But the attraction was that those days international arbitration was very well paid, was very glamorous, flying all around the world to have a board meeting in Texas, Houston, to do an arbitration in Zurich, and to the next one in Helsinki, and the third one maybe in Sweden. So it added a lot of glamour to my personal life. It had a lot more interesting than being in a counsel in court every day. And, so I stuck along with it. And I thoroughly enjoyed the journey all the way through.
It's a very, very kind and humble of you to summarize it in a fashion where it looked very easy, but definitely would have involved tremendous effort and consistency across decades. So before we jump onto the questions, a very small of what kept you motivating each and every day to come. Definitely, I mean, since you said you had a very strong knack of arbitration and there were different inclinations toward it, but what kept you?
Well, initially was the international glamour of traveling all over the globe and being paid quite generously in US dollars and Indian rupees when it was considered, the dollars were considered very strong. And that was the initial attraction. But the last 10, 15 years has changed completely. The arbitration world in India has grown much larger. And the size of claims that we are doing now in India dwarf anything I've done internationally.
Oh.
Internationally, the claims of $10 and $20 million was considered quite high. Then as the claims started becoming $100, $200 million, they in fact started going to the bigger international global law practices. And so we weren't getting that kind of work, but we suddenly started getting that kind of work in India. So if you had claims of a couple of $100 million, etc., we started attracting that work. So the work in India became 10 times more interesting than any of the international arbitrations I did. And so I focused on India, although I was a member of the CIAC court for 4 or 5 years, and we all do it by rotation, which also means that I'm appointed as an arbitrator by SEAC.
Yep.
And it's such that they always appoint you as the presiding arbitrator. Institutional rules demand that.
Yep.
And usually my fellow arbitrators are retired Supreme Court judges whom I've had occasion to appear for in the past. And like all other people in the Supreme Court, have got my SLPs thrown out in 5 minutes. And now they're sitting with me where I'm the presiding arbitrator and actually explain to them how international arbitrations run, because they just didn't have the experience. So they were more being guided by me for a change than the other way around.
No, definitely, sir. And definitely for you, experience is definitely the key to specifically in the legal field, but your experience tremendously outperformed specifically in the arbitration domain. And I just want to understand, since many of our viewers are the ones who want to be and aspire to be in arbitration practice or arbitrators, and if we specifically talk about EPC contracts, which are specifically larger ticket transactions or larger ticket disputes in the industry, what do you see, or where do you see are the challenges, or why these EPC contracts are the specific ones which go into arbitration and then drag for a prolonged period of time? Where do you see that changing, and why the need to do something in the first instance?
It's essentially because EPC contracts, well, generally construction contracts, occupy almost 50 to 55% of commercial arbitrations around the globe.
Exactly.
Construction projects are the ones that have the maximum problems. And one can see why. Why is it called EPC? It's engineering, procurement, and construction. They're actually completely different skills.
Yep.
The engineers are doing the designing of the project, and they are obviously the critical aspect, and it's something that cannot be hurried, because you're normally given a very half-baked plan by the client.
Yep.
It says, I want a new refinery, or I want a new platform, or 5 different platforms in Mumbai High to be connected to the offshore refineries. And it's a little bit vague. Usually the contracts are not sufficiently detailed. So then you come into the engineering phase, and it's a detailed engineering phase. It has to be entirely detailed. And then normally in big contracts, the client will bring in an outside engineer who is equally experienced, which is a good thing.
Yep.
But who will examine your drawings, drawing by drawing, and design. And it's a process that takes time. One doesn't recognize that the detailed engineering is at the heart of the project, and you may very well plan to do it in 3 months.
Yep.
But you can take it for granted that in most projects, it'll at least double the time.
Yep.
By the time the supervising engineers look at the drawings, suggest changes, and all of a sudden you find you're doing almost a different project, which doubles the work. It's standard practice.
Yep.
Then when you finish the engineering phase, you maybe are a little bit late, maybe you're not, depending how good engineers you are, how good or clever the supervising engineers are, how cooperative they are. Then you start the procurement.
Yep.
And don't forget, a lot of the procurement is specialized items which are being made specially for your project. So they have an extremely long lead time. In complex projects, they can be 6 months, 8 months, 9 months. It is being specially designed for you.
Yep.
So to your specifications, you want to do your inspections,
Yep.
to make sure it is done correctly and it's done to the work satisfactorily. And if it's a large scale procurement, there's bound to be 5 or 10% of rejections.
Yep.
So has a procurement supplier planned an excess capacity, or is he doing 6 different projects and doesn't have the capacity?
Yep.
So you've got to make sure the person you're procuring has spare capacity, because there's bound to be a level of rejection. If you don't plan for it, your whole project goes out of the window. You finally then, the people on the construction side have started a certain amount of basic construction, leveling of the land or procuring the barges, or depending on the nature of the project. They started, but they can't really move the project till the items they procured have been achieved.
Yep.
Then the construction phase starts. And in the construction phase, ultimately you're dealing with the earth or the sea. It never goes as planned. The surface of the earth is not what's planned. Then you find hard rock. You suddenly find there's an environmental difficulty, and environmental clearance have taken time. Or if you're in the middle of the seabed, you find the seabed very undulating. You got to relocate where your platforms are going to be. If that is not good enough, when you go to the next place, there are already pipelines there or some cables running. So you have to plan for the changes. And because these projects are so heavy cost-wise and production-wise, nobody plans for the delays. Nobody plans for the changes. If you don't plan for the changes, you have not planned for the delays. And you will find, particularly in government of India, they put out a tender. They say, okay, you have 11 months to do it because that's, or 10 months because particularly offshore, this is the monsoon season, or they've got permission from a ministry to do a steel plant in 2 or 3 years without planning for those changes. And then they have to choose the right party. So instead of choosing the tenderer within 1 month or 3 months as planned, it takes 8 months. And then they do not get permission to extend the time. So what you had planned to do in 3 years, now you have to do in 2 years. And you can't go back to them and say, look, this is completely unreasonable. You've taken 9 months to select when you had planned to take 3 months, so I've lost 6 months. So please extend the project for 6 months. You will always be told, either the ministry or the client, no, we don't have the additional 6 months. So now you squeeze your program into this and do it, which is, of course, fantastic for arbitrators because the project is bound to be delayed. Or there are going to be mistakes. And that's when us lawyers come in and help solve it, either from the client side, the contractor side, the subcontractor side, the subcontractor side, the procurement side. There are normally at least 10 to 12 elements involved in doing a large project. And delays impact each of them. To the extent that your procurement may say, forget it, I don't know when you're coming back to take the stuff from me. I've got 2 other projects coming in. I have to prioritize them. So you're going last in the line. So there are multiple reasons for delay in EPC projects. And that is why you'll find globally, construction law dominates arbitration. Globally everywhere, whether it's India, it's in Europe, in Russia, the US, everywhere. We have similar issues, and it almost feels like a lot of persons haven't learned from their mistakes at all. The mistakes are repeated almost historically in every project.
Very, very fair. And since you brought down this mistake point, just want to understand, when you draft an initial agreement for an EPC, this would definitely, the experienced lawyers like you would understand to include such strong dispute resolution clauses or mechanisms so that this dispute does not arise. So what's your take on that?
Well, historically it's changed. The answer is the contracts are drawn up by technical people, and what we call the arbitration clause, the midnight clause, just before you're signing off, you have to have some clause in case we have a dispute. They're all very good friends, the pricing has been agreed and bargained for. Who expects a dispute? So you don't bring in serious dispute lawyers at that stage. And you scribble some arbitration clause, okay, if there's a dispute, we'll go into arbitration. Unfortunately, that sometimes leads to delays in court, particularly where Indian courts are very slow. And in fact, I don't know if you saw a recent order of the Supreme Court, where one bench has asked all the high courts to give reports as to how many section 11, subsection 6 appointment of arbitrators are delayed. If you're going to delay appointment of arbitrators by 6 months, 1 month, what is the sense in trying to say, let's finish the arbitration quickly when you can't appoint the arbitrator quickly?
Exactly.
And this is a classic case. The section, the 2019 amended planned institution arbitration. The whole institution was set up. It's lying in Delhi, absolutely vacant and rotting. The physical presence is there also. And that part of the act has not been notified So that part of the act is not functioning. I mean, nowhere in the world do courts appoint arbitrators. Institutions are much better at appointing arbitrators because they know which arbitrators are specialized, which arbitrators are in good subject, which move faster, which can't move faster, which are too slow. And they will ask you, how many arbitrations are you currently doing? Every institution asks that question. Our courts never ask that. They appoint Mr. So-and-so, judge, retired judge, so-and-so, the arbitrator, because his name is popular, he's well known, his integrity is well known. But they don't realize he's doing 40 arbitrations. Where is he going to do it from? So the basic question, how many arbitrations are you doing? Or put in the Arbitration Act, then no arbitrator can do 10 or more than 10 or 12 arbitrations at a time. That gives them a lot of sense to finish those arbitration and get on and get more. But there is no control. So the same arbitrators are being used again and again. Like I said, the point is the Supreme Court asks a question, how many in the High Court? I wish somebody would ask the Supreme Court, how many are pending in the Supreme Court? I have at least 6 matters in the Supreme Court pending, whether in international arbitration, the arbitrator has not been appointed for over 6 months. I wish somebody in the Supreme Court would ask the same question that they're asking the High Courts right now.
Very fair, sir, and very pertinent question. In fact, that leads me to the next question. Since you said that, and that's globally also known fact, that majority of the Indian parties prefer Singapore or Kuala Lumpur as their seat of arbitration, or maybe London as the seat of arbitration. What needs to change to make India the arbitration hub? Why we still need to go to a foreign law to fight a dispute which is between the parties in India?
Well, that's going to take a long conversation, but just to finish the earlier conversation, the earlier part, most of the arbitrations, bigger centers in the world, have now got a dispute resolution board. So that as the contract is progressing, you have a dispute resolution board sitting almost simultaneously. So all your small disputes, is the design correct, wrong, late, etc., are decided, and you move on. So it does not lead to one large arbitration at the end or a termination of a contract, which is very serious. So we have dispute resolution boards, and Kuala Lumpur has got a very active sense. They've got their own dispute resolution board, their own rules. They're almost competing with FIDIC, which is a global organization which draws up international construction contracts. They've got their own set. And believe me, some of them are equally good, or if not better than FIDIC. So dispute resolution board for construction. So at least at the first level, the project is dealt with. The disputes are narrowed down to really serious disputes, and not every dispute is taken to that level. So dispute resolution board would be something that India needs desperately, so that every contract with the PSU today is an arbitration. ONGC, there are very, very few people who are experienced in ONGC business. So virtually every ONGC contractor is doing 6 arbitrations against ONGC on the side. So at the same time you're doing business, same time you're doing arbitrations. It's some even modicum application of common sense will tell you, why don't we have a little more organized way of doing this without a full-fledged arbitration? I mean, you have our Commercial Courts Act, which originally proposed disputes over 1 crore, but has now gone to 3 lakhs of rupees. So how do you compare a dispute of 10 and 20 lakhs of rupees with one of 2,000 crores? Why are you trying to fit them in the same mold when they don't fit? So, just it seems like a little more common sense from some very experienced chairman of Law Commission. The one who was most progressive, of course, was Ajit Shah, who revamped the whole act dramatically. But it's constantly needs revamping. So if you had a one chairman of a law commission doing great job on constitutional reforms and all other issues, and one more doing commercial work, because they're almost, if you read the newspapers today, they're full of bail applications in the Supreme Court. They're full of other issues, maybe frivolous, maybe not so frivolous. But somewhere down the line, the Supreme Court must separate these issues, what is commercial, what is non-commercial, and give priority. I'm not saying that the non-commercial issues should not have priority. They're huge constitutional matters. They should have. But you should have a commercial stream like the Delhi High Court does. You've got a physical presence, a physical commercial court, at least 5 or 6 judges sitting, 5 division benches doing purely commercial work. In Mumbai, they have one. They have one judge sitting, one commercial bench sitting, doing PILs all the time. And I don't want to name the judges, but in the last 2 years, not a single commercial matter was decided. Where do you see the improvement? Unless somebody applies his mind to these issues and is in a position to take rational decisions, starting with the chief justices of our courts, they have to start somewhere. Who will give recommendations to the law minister or to the chief justice of the Supreme Court? Somebody has to take reformation of the court on the commercial side more seriously. I think it's just simply ignored. They did a Commercial Courts Act and they thought the job was over. Nobody's analyzed how well the act has worked or not worked.
Very fair.
So, unless you have, let me give another example in Singapore, SIAC. When I was sitting there as a member, we would decide something. We would have meetings every 2 months. Okay, after every 2 months, always we had a dinner with the law minister. And he used to be sitting there, what are suggestions to improve Singapore arbitration? There are suggestions for the Singapore courts. Maybe the Chief Justice of the Appeal Court would attend, maybe would not attend, depending on his commitments. But the law minister wanted to hear from us. You are having these meetings. This is not some kind of coffee club. Tell me what I should be doing about it. So there is no dialogue here with the law minister, who is a very responsible person. There's the Chief Justice who is handling the Supreme Court and all the High Court judges, who is looking at the commercial side. Are there regular meetings between the government officials and various law bodies to say, look, here are our suggestions. Can we help in implementing them? What more can we do? There are many lawyers who are very willing to spend their time improving the system. But frankly, there is no dialogue. You have a dialogue with whom?
Very fair. Very fair. And thank you so much for being so candid and bringing what needs to change. Before we wind up, and thank you so much for your time, one last piece of advice that you would give to the young arbitrators or the young people from legal fraternity who look up to you as an aspiration. What piece of advice would you give to them?
We tried very hard. I was the president of the IAF, the Indian Arbitration Forum, elected by my fellow colleagues, to try and create some kind of, at least a semblance of an arbitration bar. An arbitration bar means law firms, lawyers from law firms, counsel, but who are focusing on arbitration, not focused on court work. So if you are going to spend all your time in court and say, I can only do an arbitration at 5:30 in the evening, you don't create an arbitration bar. You want a dedicated level of people, and this is happening globally. All the law firms have arguing counsels within themselves. They no longer engage outside counsels, except possibly in England, where the order of QC still stands, but nowhere in Europe, nowhere in US, nowhere in Singapore would you have lawyers doing court work brought into arbitration because they're very well known and very well reputed. So we tried to create the semblance of an arbitration bar, which frankly was a dismal failure, because the law firm are still engaging court counsel to do arbitration, instead of taking the lead like they've done in almost every other jurisdiction and said, forget it, we're not engaging any counsel, we're going to do it ourselves. We as a law firm do it. Okay, I've had the experience. I'm an exception. I shouldn't be the exception. I should be the rule. Every law firm should have 4 or 5 of their senior partners experience in arbitration. Say, fine, we're running it. We're not waiting for counsel if they're available, not available. We're not doing that. Well, let's try and change the system a little bit so the arbitration will run more efficiently. And we can run it. We're not before a Supreme Court where our SLPs are going to be thrown out in 5 minutes. The arbitrators have to hear you. Whether you're senior counsel, whether you're the most eminent counsel or not, they still have to give you a full hearing because all arbitration are final hearing matters. They're not interim matters, which most of our courts devote their time to.
Yep.
And a lot of the counsel, eminent counsel, are very successful with it. They're not, the nature of the work is different. So recognize the nature of the work is different. And first thing when you join your law firm, say, look, I aspire to be an arguing counsel. And if my law firm is going to find room for me to do that, I'll stay with the law firm, otherwise I'll move to the next one, even if it's a smaller one, because that's what I really want to be doing. I don't mind assisting my partner at this stage, but if I get to the stage where I'm fully capable, I want to be arguing those cases. I don't want to be running after counsel in court, making half an hour available so they can come. I need to have a different culture in the law firm. And if that law firm offers me the culture, I'll stay. If it doesn't, I will go. Because there are other law firms, smaller law firms, hungrier law firms, which will do that for you.
Absolutely, sir. Absolutely. And thank you so much for being so candid. We wish you a best of health, and please stay safe. Thank you so much for taking out time and speaking with us. Thank you so much.
Thank you very much, and it's a pleasure speaking to you.
Thank you so much.